Welcome. Thank you very much for being here. This is the time set for argument in Washington Street Enterprises, Arizona versus Larry Pellerito. Pellerito, sir. Thank you very much. Let's go ahead and begin with introductions of counsel for the appellant.
Morning, Your Honor. Curtis Edenstein for the appellant, Lawrence Pellerito.
Welcome.
Melania Seconder and co-counsel Sanford Germain for Washington.
Very nice. Welcome. Let me go over a few preliminaries. I'm sure you know them, but just so that we're all on the same page. Each side, of course, has 20 minutes. The appellant may reserve time for rebuttal. It would be helpful to the court that when you go to the lectern, if you would like to do so, let us know, and we'll try our very best not to poach on your rebuttal time by asking questions. Let me advise counsel that we have reviewed the briefs. We're familiar with the arguments. We have discussed and conferenced your case this morning, in fact, so you might like to take our preparation into account in your remarks today. We are recording these proceedings today, both audio and video, thank you. I guess I'm still back in the old time when we only did audio. And you may go to our website if you would like to listen and review the recording. With that, we'll go ahead and begin. One last point. When you go to the lectern, because we are recording these, could you please restate your name? That way, anyone who wants to review the video, the audio, will know who's speaking. And with that, let's go ahead and begin.
Good morning, and again, I'm Curtis Edenstein for the appellant, Lawrence Pellerito. I would like to, at this point, reserve 5 minutes for rebuttal. I know I don't have to say this, but I'm going to anyway. One of the core principles, of course, of our legal system is due process, and that's a basic requirement of that is notice and an opportunity to be heard. It's never more true than in the instant case. This dispute is really about a month's rent at $1,600 under a month-to-month tenancy with a deposit of $700, maybe $1,000 due allegedly, and the plaintiff sued for some $22,000, got a judgment that was $36,000 by the time it was paid, and quite frankly, Mr. Pellerito has not had an opportunity to rebut that in court. Now, I'm going to argue today under the standard of review for clearly erroneous, with the added proviso that, since this is a default judgment, any doubt should be resolved in favor of a trial on the merits. And even though I'm going to discuss that standard of review, we submit it should be de novo. All of the rulings of commissioner duty were done on the basis of the affidavit of Mr. Pellerito and the negative inferences that Mr. Commissioner Duty drew from that.
Well, didn't he also have the opportunity, or at least Mr. Pellerito, I understood, testified as to on a limited basis, but could have testified to a larger basis?
Mr. Pellerito was at the hearing, did testify that the place where the service was supposedly made was not his usual place of abode or residence. He was not questioned by Washington's experienced counsel. He saw what was happening. Commissioner Duty announced before any evidence that he gave us his thoughts on it. But in point of fact, if you look at the minute entries, especially when he denies or grants them fees under a particular statute, which I'll discuss, it was all done on the negative inferences because there was no evidence that Mr. Pellerito resided at that address. And both sides agree. Washington Street said in a later brief it was clear from the outset of what the ruling was going to be, and that's why they didn't ask any questions at the hearing. So even though we're going to argue from a clearly erroneous standard, we submit it should be de novo because this ruling was made immediately, and that was confirmed in subsequent minute entries.
I'm a little mystified.
Yes.
How would we, in a principled fashion, apply a de novo standard of review here? I mean, I know we can do it, but normally we follow our own precedent. How would we do that here?
It was based on the affidavits. The only testimony at the hearing was from Mr. Pellerito, who simply confirmed what was said in the affidavit, and that was it.
Well, beyond when he acknowledged that he had either spent a night or the night. I mean, he added some additional information, didn't he?
I asked him if he had spent some nights there or a night there, and he said
right.
yes. But
Right.
no, that I don't think that goes beyond anything. But again, we're not.
Yeah.
We're saying it. We think it should be, but we're here today to argue on the clearly erroneous standard. So, is the question? The question is, Commissioner Duty found that there was. His usual place of abode was at the Carolina address, but there was no evidence of that at the hearing. There was nothing admissible at that. The two people that had affidavits swore that no, that wasn't his usual place of abode. His driver's license, which was issued only a month prior to the service in October of 2009, showed his address at the house he owned on Florentine. And there was a beneficiary deed that the plaintiff produced, which showed that he owned the Florentine house. He deeded it in July of 2010. He did a beneficiary deed essentially take effect upon death. But that's 9 months after the alleged service. Commissioner Duty said that, well, we can infer from that that somehow there was a renting involved, which absolutely no testimony about, and that somehow that this suggests he was living at the Carolina address, which there's absolutely no evidence to support that. It's an improper inference.
Do you think the law, excuse me, sir.
Yes,
do
sir.
you think the law recognizes that an individual can have more than one place of abode?
Well, it's your usual place of abode, right?
Right.
I didn't find any cases that say that. And
So usual would be, we'd have to decide one versus another. That has to be.
I'm not saying I found a case that says that either, Your Honor. But this was not his usual place of abode on Carolina, and that's what the affidavit said.
Let me ask you a question here. Under the clearly erroneous standard, what we're looking at as a reviewing court is basically whether there was evidence, reasonable evidence, to support the trial court's decision here. The evidence that we have would be, of course, the process server's affidavit, the statements that he attributed to the woman at the house, that Mr. Pellerito lived there. We then have his acknowledgement at the evidentiary hearing that he had spent or some form of night or nights there. And then we have the overall issue about how this trial court viewed the credibility of Mr. Pellerito and the other affiant. And when you put all of that together, doesn't that, maybe I might have gone a different way if I had been a trial judge here, but doesn't that support this trial judge's determination?
No,
Isn't that enough?
We submit it doesn't.
Okay.
The process server's affidavit, when he testifies, I handed it to somebody where he has firsthand knowledge. I think that's something that's admissible. When he just says that's somebody's usual place of abode, that's not based on anything, and even if it is, it's
I would
hearsay.
exclude the conclusion, but the facts, just the facts that he put into. It wasn't a usual place of abode. The statement was, he's living here, I believe.
He is testifying what he said somebody else said. Hearsay, clearly hearsay. And that should not be admissible.
Well, wouldn't it be the person's present sense impression? If a question's asked and gets a response, doesn't that come in as a present sense impression, even though it has hearsay components?
I don't think it's an exception to the hearsay rule. I think that when you have a present sense impression like that, it's either an excited utterance or it's somebody's state of mind. But to me, it's not. They're trying to prove it for the substantive fact that Mr. Pellerito, that was his usual place of abode, and the process server's statement that that's what he thought, to me is conclusory. It's not based on firsthand knowledge, and it's not competent evidence that that's his usual place of abode. And certainly, the only thing it was based upon was his allegation that that's what the person that he talked to said. And he didn't know who that person was. And we submit it's not competent evidence. And the only evidence at the hearing was that wasn't his usual place of abode. And the driver's license backs that up. Now,
You know, again, looking at the certificate of service. The process service stated that she was not Mrs. Pellerito. She did admit that Larry Pellerito does live at this address. She said that he was not expecting anything and told me to leave. Now, we have that. We have the first affidavit from this person, and then we have a second affidavit from this person who then acknowledges that, yeah, she owns that house. And isn't there, and this is what the trial court did, there's a reasonable implication that the person who owned this house, who he then married 2 months after the service or thereabouts, was an appropriate person, or acknowledged this is information that the court can rely on. I'm having a hard time. He doesn't make the statement, a legal conclusion, a place of abode. It's just that he does live at this address.
He says that's what Denise Pellerito said.
That's right.
That's right.
Right.
And that's a hearsay statement which Mrs. Pellerito definitely refuted in her testimony or affidavits that were before the court.
But why does the court have to believe that?
Well, you know, if you're going to resolve doubt in favor of a trial on the merits, and you've got the person who was there, and you know, we think, well, first of all, it's not competent evidence to say that somebody said that. The process server was not there. He just stated in his affidavit he was not subject to cross-examination, and that's all he stated was that some clear hearsay that somebody told him this. And we submit that's not admissible evidence.
Doesn't the fact that it's a process server who's essentially a officer of the court and files that, that creates the presumption that it was fair service, and then it would be Mr. Pellerito's responsibility to overcome that by clear and convincing evidence.
Well, with whatever the process server has firsthand knowledge of, we submit that's the rule. I don't know why it's the rule, but it's the rule. Significantly, Mrs. Pellerito is also an officer of the court. She's a managing court reporter for the Superior Court. But, and I don't mean to ignore it, but there are some other points about service at the abode that were not, clearly not complied with. Number one, you have to leave it with a person. And it's clear it was not left with a person. He just dropped it there.
Well, what do you do with all the situations where we see lots of them where the people won't come outside, and so the process servers leave it at the door because they're in there hunkered down?
When that's the person you're talking to itself, I think the courts generally find service because the person knew that. But
Right.
when you're abode service with somebody else that's not even related to this case, there's no reasonable assurance that the defendant's going to get noticed. And that's why courts have distinguished when you don't leave it with a person who resides therein. They didn't leave it with a person who resides therein. Also, there was no proof at the time that Denise Pellerito resided therein. The court just said there's a presumption, therefore she must reside therein. And so those two prongs of the rule were not complied with. Actually leaving it with the person and with a person that resides therein. In addition, and I think this is the key to the case here, Commissioner Duty said that you received the complaint. There's a different standard courts apply when a person actually receives the complaint, but there was absolutely no evidence that Mr. Pellerito received the complaint. And if somebody's suing you for $22,000 and at most there's $1,000 in issue, yes, you're going to answer that. You're not just going to let it go by default. So I think it's submitted. Commissioner Duty used a different standard. He believed that Mr. Pello received it and just ignored it, and that's what he said. And courts apply a different standard when the person who's the subject of abode service actually get the complaint, and they apply a more liberal standard. In this case, I think that's what he did, but there was absolutely no evidence that he actually received the summons and complaint.
I agree with you. There was at least one situation where he seemed to assume that the future Mrs. Pellerito turned her head and, was talking to someone else, but there was, at least in reading the affidavit, there was no indication, that ever occurred. So.
Correct, and Commissioner Duty assumed that she was actually talking with somebody else there, but there was no proof of that whatsoever, no evidence of that.
What do you make of the fact that when the notice of when the default notice was sent to that address, that it wasn't returned as undeliverable?
It wasn't. There's no evidence of that.
Well, there's no evidence in the court file that it was returned. Obviously, there
wouldn't
the
be
affidavit. Well, if it came back, well, there could
No,
be.
it's just mailed, Your Honor, so it would come back maybe to plaintiff's counsel, but if it were mailed, it wouldn't be the only time there's something were not actually mailed. But that wasn't an issue that was raised below. That was a statement made in the response brief that said, well, it didn't come back. There's no that wasn't an issue. There's no evidence of that. And on attorney's fees, the commissioner duty awarded roughly $8,000 in attorney's fees. There's only one basis for that. It has to be solely for delay or harassment. He wouldn't grant a hearing. He just gave the minute entry based on the affidavit again and the negative inferences that and he says this in his minute entry, that he drew from that and awarded plaintiff the full amount of attorney's fees requested. But delay or harassment means that, and it's solely, the statute says solely, that you can't have an arguable basis. We clearly had an arguable basis here, and I don't think that argument is arguable. Clearly, there was evidence that he didn't receive it, that there was no evidence that that was his usual place of abode. We raised significant issues, but the court awarded attorney's fees anyway under the finding that it was solely to delay or harass. They never even claimed delay or harassment. It was one sentence at the end of their response to our objection to the garnishment that they said, they mentioned the statute, and Commissioner Duty said, well, you were on notice to put on all evidence about attorney's fees at that hearing, which we submit is not the law. But that's why he did not grant a hearing, and he awarded fees. We think that is clearly erroneous. We think that is a de novo review, whether or not we raised anything we raised had an arguable basis. So I will save the time I have left, and thank you.
Thank you.
Melinda Seconder for Applee. Our position is that there was plenty of evidence upon which Judge Duty could make the findings he made. Our position is that appellant failed to prove by clear and convincing evidence that the service was not accomplished as stated in the process server's affidavit. He argues about usual place of abode. A case he cited, Melton versus Melton, stated, further, dwelling house or usual place of abode will be liberally construed to affect service if actual notice has been received by the defendant. Here we submit that the Commissioner Duty's finding that Mr. Pellerito actually received notice is supported by the evidence.
If, in fact, we follow what the process server, where the person said he lives here, I'm going to serve him, and I'm leaving it at the front door, how does that get to actual notice?
That gets to actual notice by something Mr. Pellerito testified to. At page 11 of the transcript, he said, if I would have known that I was going to have to pay $36,000 back then, I would have definitely gotten an attorney back then, sir, and definitely come to court and fought it then. Well, if his claim is he didn't have knowledge back then, how would he back then have gotten an attorney and come to fight it in court back then? That testimony alone suggests, and Commissioner Duty could have found from that testimony, that Mr. Pellerito actually had knowledge back then, back when he was served. Commissioner Duty also could have found that he had knowledge because of his intimate relationship with the owner of the house. The lady who said he lives here, he married that lady 2 months later.
Well, but we have to focus only on the time of service. Whether it was a whirlwind romance or anything else, it's the time of service that is the focus. Whether he, married her and moved in there, I don't think you can extrapolate that back and merely say, because she said yes and he then later married, that in fact that has occurred.
Well, she said yes, he resides here. She was the owner of the house. They have never claimed that any other female was at that house on that day when the process server came. In fact, Mr. Pellerito testified, again at page 11, he said, but as for that gentleman that said that he said in his affidavit there that she said that I live there, if she was here today, she would take an oath saying that she did not say that to that gentleman.
Let me ask a couple questions here. In Denise's, and forgive me, I'm going to refer to her by her first name, or I guess, excuse me, I should say Mrs. Pellerito, filed her second affidavit in support of the new trial motion. In paragraph 3, she says, when a person who may have been a process server appeared at my residence. So isn't there then information in the record that it was her residence at the time of the attempted service of process?
Correct.
So let's assume then that's a fact in this record. And let's also assume that there was an actual notice. Let's put aside that, okay?
Okay.
Because that seems to be in dispute. Then you emphasized the process service statement that Ms. Pellerito supposedly said, yes, he lives here, or words to that effect. Why isn't that hearsay?
That is not hearsay because I think, as Judge Portley already mentioned, it is a present sense impression. It's also...
How's it a present sense impression?
Because she said it to him at that time, and so he formed the impression that Mr. Pellerito lived there.
But it's... that's not my understanding of how the present sense impression exception to the hearsay rule works.
Yeah, I think, to join Judge Norris, I think that requires the declarant to be describing an event made while the declarant is perceiving the event or condition or immediately thereafter. I mean, she's arguably, if believed, she's describing her condition, or in other words, the occupant of a house in which someone else is living, but she's not seeing it, which brings it, I think, outside the normal context of the present sense impression rule.
I think one has to look at this in the context of a process server, though, because a process server, if he walks up to Mr. Smith on the street, who's actually Mr. Jones, but he doesn't know that, and he says, are you Mr. Smith? And the man goes, yes, I'm Mr. Smith. Mr. Smith, consider yourself served. And he provides the service. He will never know for a fact, unless he knows Mr. Smith and Mr. Jones, that they're pulling something on him. Now, whether that would actually be service on Mr. Smith, if really you serve Mr. Jones, we'd have to argue that at another date. But here, there is evidence besides her statement. There's also other evidence that it was his usual place of abode. He used it before this time as his mailing address. It came up on a person search as being his primary address. It was the #1 address listed on the person search done through LexisNexis. The mail sent to him after service didn't get returned as undeliverable.
Is there anything in the record on that?
There is a statement by counsel in a memorandum. It was not objected to or disputed by the
No facts in
opposing
the record, it's just argument.
party. It was just as an avowal of counsel. Correct. It's not an affidavit of counsel. It's an avowal of counsel. And so under the case law, since it wasn't objected to, no citation to Prairie State Bank or any of the other cases holding that if you object, a statement of counsel is not a fact. but it was an eval. Had they objected to it at the time, certainly a declaration could have been submitted by counsel, but they didn't object to it at the time.
Are there any other grounds for admitting the statement of the woman on the balcony that he lived there, other than the it being a present sense impression and therefore not hearsay?
That wasn't argued, that it was hearsay or objectionable, and thus I haven't really given it much thought.
Was there an objection made at trial to that?
To that statement? No.
I'm sorry, maybe I missed this, but I thought Mr. Pellerito, through counsel, argued that that statement was in fact hearsay.
If he did, it's
Okay.
not in the brief.
At trial, either in
Yeah,
the
and I didn't-
at the hearing or in his.
It's
written
not in the
materials.
transcript.
Okay,
It maybe it's an emotion and I've missed it.
that's okay. We can look.
Okay. There's another, they need to impeach the affidavit of the process server by clear and convincing evidence. There's no evidence what Mrs. Pellerito did with these papers after they were left on her porch. Now, of course, when she was disputing that she talked to the process server, when she was, you know, when they were disputing that the process server even ever came to the house, they couldn't admit what was done with the papers. But certainly by the time of the motion for new trial, she could have provided an explanation. She could have provided an explanation at trial if she'd come to testify.
Said in her affidavit, in support of the new trial motion, I did not give Mr. Pellerito a summons, complaint, or any other documents. So presumably she didn't give them, so she,
Threw them away.
well, or disposed of them in some form or fashion.
And again, that would have to be a matter of credibility for the trial court. Now, the trial court didn't see her, but the trial court saw Mr. Pellerito, whose statements to the trial court were inconsistent in that while denying he ever received the papers, he talks about, you know, if I'd known back then that I was going to have to pay this, I would have hired an attorney back then.
Let me ask you on the back then statement. I will confess I did not read it the same way you have construed it. I read it more of, well, if I had known I'd been sued, I would have gotten a lawyer. He wasn't acknowledging that at the time of the service or shortly thereafter he knew he had been sued. I didn't read it that way.
I think the way that I've read it is a reasonable interpretation. I certainly think that although you could interpret it more than one way, because appellant has interpreted it yet a different way, that Commissioner Duty could have relied on that to make a finding that he actually got notice of this lawsuit because of the back thens. I would have definitely gotten an attorney back then, as if he thought he would never have to pay $36,000 back then. And so he didn't think that was a possible outcome back then. But if he'd known it was a possible outcome back then, he would have gotten an attorney and fought the case. So that supports Commissioner Duty's, that interpretation of that testimony certainly supports Commissioner Duty's finding. With respect to your question, Judge Norris, earlier to appellant, which was, can you have more than one place of abode? I don't think they would have had to use the word usual if you could only have one. Your place of abode then would be your place of abode. Your dwelling house would be your dwelling house. But by using usual place of abode, they would, I think the rule recognizes that you can have more than one place of abode. There's no, he's admitted he's spent nights at the Carolina address. There's evidence that his mail was sent to the Carolina address. What he didn't do was present evidence saying how much time he spent at either address. Florentine, if he spent any time there, there's nothing in the record that shows how often he was there, as opposed to how often he was at the Carolina address. Given that he was using the Carolina address as his mailing address, one can certainly infer that that was his usual place of abode.
Do you see any, let me ask you this way, is your position undercut by the first writ of garnishment regarding mailing address that had your client saying that the last known mailing address of the judgment debtor, Mr. Pellerito, was on the Florentine address? Do you see, does that undercut your position?
I don't believe so, because as we've already, as I think I've already argued, that you can have more than two you can have more than two abodes. And at one point in time, after the service of the complaint, I think that the people search may have reversed the two and put the Florentine address above the Carolina address. But at the time of service, the Carolina address was the primary address. And so, as you pointed out, we need to focus on the time of the service and not some later time. The writ of garnishment was multiple years after the default judgment was entered.
Well, no, the first one was a couple of months.
Oh, I thought you were talking about the writ of garnishment
Not
on
the
the
bank of them.
Okay.
Yeah, okay.
If defendants could come into court after a default judgment was entered, after a writ of garnishment was served, after a bank had withheld funds to satisfy the writ of garnishment, and simply say to the court, I swear to you, court, I didn't live there, and I never received it. The plaintiffs would be hard-pressed to obtain service of anyone who failed to come to court and defend. You have to present something more in the face of an affidavit from a process server and in the face of the testimony we've heard and the other evidence that's been presented to Commissioner Duty. You have to have something more than, I swear to you, I didn't live there and I didn't get it. And what Commissioner Duty
well,
was...
what more would be required to create if we were looking at this under Rule 56, a genuine issue of material fact?
You could have witnesses. You could have Mrs. Pellerito's neighbors say, I never saw his car if he parked in the drive as opposed to in the garage. You could have other people, the neighbors at the Florentine address. His lights were on, 29 out of 30 nights in a month. There's all sorts, there's all sorts of ways you could, by clear and convincing evidence, show, if you can, that the process server was simply wrong. But just to come in and say, I have a driver's license, has the wrong address on it. They killed my address, the post office did. Doesn't mean I live at the old address. It doesn't mean anything. Where my you cannot update your voter's registration. So that too doesn't matter. You can have witnesses who can come in and can impeach the service by something more than just the defendant saying, I don't live there and I didn't receive the papers, because any defendant can come to court, and if the judge has to believe that, and that's clear and convincing evidence that you weren't served, then any defendant could use that tactic. And here, Commissioner Duty...
Well, wouldn't that then really get back to, I think, what Mr. Ensign said, at least the courts have said, then to the extent that the bank could interplead the funds, then you could litigate the merits of the claim.
Then you're putting the plaintiff... The plaintiff had to file all its pleadings, serve its pleadings, and got a judgment. Now you're going to undo all that because the defendant says, I for sure didn't get it and I for sure didn't live there. Now you're going to go back and retry everything on the merits. the point of the judgment is finality.
Well, there has to be service. It's
There
void.
has to be service. But we have Arizona law on point that says that to impeach the process server, you have to have clear and convincing evidence. You can't simply come in and say, I didn't live there, and I swear I didn't get it. When you have all of the other evidence from which the commissioner could conclude.
But if you take out, sure, the burden's on the purported defendant to come in and impeach the process server. So you take the process server's affidavit, which if you take out the arguable hearsay statement by the woman on the balcony that he lives here, then you've got the process server looking up. There's various databases that show him living there, that show this being his address. You've got the woman on the balcony not saying, I've never heard of the fellow. I mean,
Right.
Clearly, there's some relationship there. He admits he has stayed there. I mean, is that enough? Just the internet databases and the concession that he has stayed there. Is that enough?
Yes. For to prove service?
No, well, to prove that's his usual place of abode.
Right, to prove valid service. To
Right.
prove the facts necessary for valid service.
Is that's his usual place of abode?
Right. And
That he has stayed there, and that various databases list the address as his.
correct. But how else is the plaintiff going to find where the defendant is?
Well,
that's
in
not
the
my,
old
that's not my
days,
question. My question is, I mean, yeah.
Yes, I believe so. I believe that that clear and convincing evidence to impeach the process server's affidavit of service and all the other evidence that supports what Commissioner Duty finds that there was proper service is something more, has to be something more than I swear I didn't get it, I swear I didn't live there. That wasn't my usual place of abode. And I think there has to be substantially more than that, or you can impeach service in any case.
But I guess my question goes to whether the process server has made it, whether the plaintiff's made an adequate case to begin with, whether there's enough evidence to support it. I mean, absent impeachment.
Well, the process server always has to rely on the process server doesn't know everyone who lives in the state of Arizona. The process server always has to rely on the information provided by people and by databases to determine what is his usual place of abode, where should I go to serve this person so it's valid service. So he can rely on what this witness said to him to form his belief that this is valid service. This is where the guy lives.
Okay, thanks.
Thank you.
Thank you very much. Your rebuttal?
Yes, very quickly. Courts have said that you have to have the finding that it was usual place of abode. Otherwise, there's no jurisdiction obtained, and courts can't just graft a new basis for jurisdiction. The driver's license was issued 1 month prior, not maybe counsel's experience. And again, the standard of review is that doubts must be resolved in favor of a trial on the merits. And there clearly was doubt here. At the very least, there was doubt here, but it was not resolved in that way. So we think the judge erred when he didn't resolve the doubt in favor of a trial on the merits.
Well, even if we have doubt, apparently Commissioner Dewey had no doubt.
No, he didn't have any doubts.
Well,
he said he didn't have any doubts.
Well, that's right. And,
But
and
does
that's
he,
the hurdle you have to overcome.
well, but did the evidence create doubt? Does it legitimately create doubt? And we say it certainly does. We've got the only people that testified said, no, that wasn't his residence. On the question, I looked it up in the transcript there, I asked him if he had ever spent the night there, and he said yes. Commissioner Duty was concerned about lack of candor, so I asked him that question just to indicate, yes, he had spent the night there, but there was nothing else beyond that. Again, there were no questions asked by the opposing counsel. The Internet search in the response to the motion to vacate had a bunch of inadmissible evidence. It was all inadmissible, and it listed no fewer than 4 addresses for Mr. Pellerito, as pointed out in our reply. And the judge indicated he did consider this evidence presented by a plaintiff, which is improper. It was not admissible evidence. It was just an internet search, a bunch of stuff. It was not documented in any way or authenticated in any way, and it listed 4 addresses. So we submit that that's not proof that the Carolina address was his usual place of abode. The back then argument, Mr. Pellerito said, if I had known about it, then he would have fought it, of course, because it was asking for $22,000 on a case that's really $1,000 in dispute. That doesn't mean that he knew about it back then. He, in response to Commissioner Duty's question, said, if I had known about it, of course I would have fought it, which I think anybody would say. So we submit that's no help to to Washington in this case. On Denise Pellerito's affidavit that she resided there was actually submitted in connection with the motion for new trial and after Commissioner Duty's ruling. But again, it wasn't left with anybody. There's no dispute about that. The process server doesn't even say that he left it with anybody. We say there's no special rule for admissibility of a process server's affidavit. It's like any other affidavit. It needs to show firsthand knowledge that you're competent to testify to those facts. And in this case, he's just simply not competent to testify to those facts. And therefore, it doesn't establish, we submit, that abode service. Because the two things, one actually says leaving it with somebody there, not just putting it out on the porch or somewhere out in the bushes or anything like that. And again, when the process server is talking with the person who's going to be personally served, that's one thing. But if he just leaves it with nobody, then there's no reasonable assurance that the defendant's going to get it. And that's why it needs to be, in accordance with the rule, actually left with a person. It was not done in this case. So we submit that if the court applies a standard of clearly erroneous, but with the modifier there that any doubt is to be resolved in a favor of trial on the merits. Now, Mr. Pellerito just simply never got his chance to appear in court and respond to the allegations, and we submit he should be given his chance. He didn't. That wasn't his usual place of abode at the time. He owned another property, and that's what he testified to. We submit there wasn't any evidence to support it, but if you're looking at doubt, you have to resolve it in favor of a trial on the merits, and that was not done here. So we would ask that you reverse it, and especially on, well, on both issues, but the attorney's fees, which I didn't speak about. I just want to mention that too. Thank you very much. We appreciate it.
Thank you very much, counsel. We appreciate your arguments and your preparation today. We're going to take this matter under advisement and we'll issue a decision in due course. We're going to recess briefly so the bailiff can set the courtroom up for the next argument. Thank you.